Hello, Olivia. I see you now.
Hello.
Hello. Link Emma. Right. I'm sorry. Emma Huff, are you on? Yeah, I see you. You're on. Cynthia. No, there she is. Well, good evening, ladies and gentlemen. The time now is 8:03. And I'd like to welcome everyone to the Healthy Homestead, Protecting What We Build webinar, sponsored by the National Trends and Services and in partnership with our Black Cares initiative. I will turn the meeting over to for greetings and welcome to our chapter president, Cynthia R. Boyd.
Good evening, ladies and gentlemen. Thank you so much for joining us this evening. We are happy that you have included us in your evening schedule. We have our committee has planned, our FACET has planned a very informational webinar for us this evening. We worked so hard and long to have a home, and we don't want anything short of disaster to come and take that away from us. So we're going to, all those questions that you had but didn't know who to ask will be answered tonight. So sit back and relax and enjoy tonight's webinar. Thank you.
Thank you, Madam President. We'll now have our Linkspiration and prayer by Beverly Hill Jackson, a member of the LaGrange chapter.
Good evening. Our Linkspiration this evening is coming from All Things Beautiful, Devotions for Women. Plans and goals. Commit to the Lord whatever you do, and he will establish your plans. Proverbs, the 16th chapter, the 3rd verse. When we commit our plans to the Lord, we need not worry about the end game. We're not relying on our own abilities to succeed, but on God's gracious favor with us in every endeavor. Even if we fail, God will use it for our good. He is able to establish us in loyal love, no matter the result of our efforts. Let's join our hearts and hands with God's today and trust him with our plans. Let's rely on his leadership to guide us in wisdom. Let's trust his power to move mountains on our behalf. As we consistently show up for our goals, God will bless us. He will redirect us when necessary. He will open doors that no one else could. He will shut others for our good. Above all, let's trust his character. He sees what we do not, and he is faithful to his purposes. Let's pray. Loving Lord, we trust your faithfulness more than our own expectations. You are endlessly good and you never fail. You restore, redeem, and liberate in your love. We commit our plans, our days, our hopes to you. Lead us, Lord. Amen.
Amen. Thank you so much, Beverly Hill Jackson, for the inspiration and prayer. As we think about plans and goals and we move forward, not only trusting, but also being faithful in those opportunities that we are truly blessed with. Our speaker today, and I'd like to introduce to you, and please join me, all of you, if you would join me in welcoming our presenter for this evening, Olivia Smith, Esquire, who is a partner in the SR Law Group. Olivia is a native of Georgia and a graduate of Spelman College in the class of 2004, where she received her Bachelor's of Arts degree in political science. And in addition, she's a graduate, 2007 graduate of Loyola University in New Orleans College of Law. Olivia has been practicing law for more than 13 years, starting as a criminal defense lawyer and transitioning into estate planning and elder law due to a personal family experience. She is the owner and partner of SR Law Group, a boutique law firm focusing on estate planning, elder law, and probate in the Black community. She's also the co-host of Black Parents Aging, a podcast that helps children of aging parents navigate the changing landscape. In addition, Olivia is actively engaged in her community and her church, from volunteering and assisting candidates who are running for office to mentoring young women and girls. Olivia also serves as an estate chair for the Georgia Association of Black Women Attorneys and on the advisory board for changing how individuals prosper, or the CHIPS project. Again, please join me in welcoming our speaker for the evening, Olivia Smith.
Thank you so much. Let me just start off by thanking you for having me. I so look forward to being able to present and share what I know, in the hopes that it will help somebody. If I can share my screen.
Okay. Let me see.
Okay, yeah. Okay, let's see. Okay. So when you said protecting, what you built, what comes to mind for me is legacy. And so I kind of want to interweave that into what we talk about, because I think it's something that is important that we kind of keep on our minds as we are accumulating wealth and gaining assets. She's already given this. So this is what my firm does. We do estate planning, we do elder law, which is really long-term care planning for people, usually 60 and over. We do special needs planning, guardianships, conservatorships, probate administration, and then we do some litigation as well. And so what I wanted to kind of center the conversation on this evening was really talking about experiences that I've had with real people, because I feel like that drives it home in a way that perhaps me just, saying here's a trust and here's a will might not. You'll get some of that too. But the first question I really would like for you to consider is what happens when we don't protect our legacy? What happens when we don't protect what we've built? And I want to tell you about a little old lady that lived in Floyd County, who had worked for 50 years as an in-home maid, housekeeper, and childcare. She'd worked for this white family for 50 years. She'd raised their children. She'd maintained their home. They were a well-to-do family. They had a real estate development company. But this little lady was pretty savvy. And so she had accumulated 8 properties over that time. And so she owned 8 different properties. And then she started to get sick. And she started to get sick. She called her grandson who lived in New York and asked him to come down. And so when he came down and was trying to see about her, you know, get someone that would be willing to come and sit with her, he came across a will. And he came across a will, and the will had left everything to the white family that she worked for. And so he asked, these were papers that were at the family's house. She wasn't going to be able to work there anymore. So he went to get her stuff. And he asked her about it, and she said, you know, I haven't done any wills. Like, I don't know what you're talking about. And she said, but since you're here, that is something I want you to do. I have these properties. I want to make sure they go to you. Her child had already predeceased her. She told him to find an attorney and get the paperwork drawn up. He did not, though. He went to Office Depot and he got a template. And he proceeded to fill out the forms, you know, how he thought they should be filled out, how his grandmother wanted. And then his grandmother passed. And he went to probate court to probate the estate based on the will that he had drawn up for his grandma. And the white family filed into the case and said, we are, you know, she left all of these things to us. And so, and the will that you have is not valid. And so at this point, he called my office and I looked at the will and I said, ooh, okay, you know, it wasn't drafted well. And there was a major part that was missing, which was who gets what. That was not in there. But I was like, okay, let's see, because this is your grandma's legacy. She worked this hard. She did not work this hard, accumulate all of these assets, property in desirable areas that were going to be worth something, for it to go to a family that didn't need it and, you know, wasn't a part of her family. And in about a year and a half of litigation with this man, we get to trial earlier this year, and the church member, the court is full. He's called in the church members, everybody's there, families there, court is packed, and opposing counsel comes in, asks me to the hall, and says they're going to drop the case. I felt good about our chances, but they were betting on the fact that he would not have enough money to be able to fight them for his grandmother's estate, for her assets, and that they would just be able to prolong it long enough for him not to be able to afford to continue fighting. That wasn't the case. He was able to, he was awarded all 8 properties. And I told him, I said, no, you see what happens when you don't effectively do your planning. So now you own 8 new properties. I need you to do your estate planning. That's what happens when we don't make sure the legacy is protected. Now, I had all of these questions about how did you not know what was going on with your grandmother, and how often did you check it? All of those questions. But at the end of the day, his grandma had worked 50 years and accumulated this property to be able to pass down to her family, her kids, her grandkids. And it was almost taken by the family that she worked for. And so if you don't protect your assets, someone else will be very happy to come in and take them over for you. And so one of the ways we ensure that our assets are protected is by doing our estate planning. And it is simple. It's making a plan in advance and naming who you want to receive your belongings. That's it. Long-term care planning is making a plan in advance of needing long-term care to protect your assets, and qualify for assistance if you ever need to go into a long-term care facility. So why, people ask all the time, like, why plan? I'm going to be dead. I'm not going to be worried about it. I'm going to let them figure it out. Why would I go through this? Why would I pay all this money? And a lot of people feel like I don't even have enough. Like, why would I go through all of this for just what I have? And here are some reasons that you want to plan. You wanted the same people that you cared about and wanted to take care of while you were here. It gives you the opportunity to still take care of them even after you pass away. You don't want the government to get it through taxes and probate. You might want to avoid probate. And one of the things that I think we look over is you just want to have your say. As we get older, sometimes your word and your opinion and what you want, people seem to not pay as much attention. You've worked your whole life for whatever you have, and you should be able to say what happens to it when you aren't here. You should be able to have your say. And basically, the planning is accumulating, protecting, and then distributing what you have. Those are the three big chunks of what we're talking about when we're talking about a legacy and we're talking about protecting what you've built. And so I've heard time and time again that, I don't even have an estate, because people think estate planning or having an estate means that you're a Rockefeller and you have millions, or you're Oprah and you have millions and millions of dollars. And that's just not the case. Everyone has an estate, and it's comprised of some of these things: your car, your home, any other real estate, your bank accounts, investments, sometimes life insurance policies, your personal possessions. All of those things make up your estate. And so mostly all of us at least have some of these things. And so all of us have an estate that we need to make sure that we're protecting. And then planning is just minimizing risks. That is what it comes down to. And the risk is the probability or threat of a negative occurrence that may be avoided. So we are preemptively taking action to avoid someone coming in and taking property away from our family, or avoid our family fighting it out in court, in probate court. We're going to go ahead and plan, so we'll preempt all of those things. These are some of the things that I've seen happen when we don't plan. Spouse remarries and new spouse gets all of the things that you worked for with your spouse. The government winds up with your house. You use all of your money paying for long-term care, whether that is a nursing home or assisted living facility. Or you get Alzheimer's or dementia, and at that point, you're not able to make those decisions about yourself or your money, or your other assets. You've waited too late. We get a lot of calls from families that have a loved one that they want to make sure they do their planning. They've been diagnosed with Alzheimer's or dementia. But part of that means that you have to have capacity. You have to be able to make decisions, and I have to feel comfortable that you can. And so sometimes they've waited too late, and that person doesn't have capacity. That person isn't able to clearly express what their wishes are, what they want to happen with the things that they've accumulated. And so at that point, it's too late for them to sit down with me and make a plan. And so we have to look at other alternatives. A will is probably the most common and most known document when we're talking about estate planning. Sometimes it's called the last will and testament, and it is a legally binding document that states your final wishes and appoints a personal representative. And the personal representative is really there to handle the business of the estate, your last affairs, to kind of tie everything up in a bow. These are the requirements in Georgia for a will. You know, we still haven't progressed past age 14 as far as creating a will. It must be in writing, and you must be of sufficient mind and memory to create the will. And then you have to have 2 witnesses that aren't going to receive anything in your will. They have to witness at the end. And that's really all you need to create a valid will in Georgia. The benefits are it allows you to name the person to receive your property. It allows you to leave burial instructions. And it allows you, if you have minor children, it allows you to name a guardian for those children. Some common mistakes: a simple or do-it-yourself will. And that is what almost got my client messed up in the story that I told you at the beginning, that he went to Office Depot and got the template and felt like he could fill it out. But he didn't understand some of the vocabulary. He didn't understand what some of the clauses meant. And so he did not completely fill it out, which caused us a lot of headache later and cost him more money later than he would have paid to just hire an attorney to do it. Depending on a life insurance on those beneficiary forms and using that as a way to do your estate planning, or placing children on your bank accounts or on the deed of a family home. I hear a lot of people that say, oh, I've just put my kids on my account, so I'm good. And what I always want to make sure that you consider before you make that decision is, when you place someone on their account as an owner, then they become an owner of whatever's in that account. And so if anything happens in their life, if they get divorced, if they get in a car accident when they're at fault and the insurance is insufficient, if they get sued, if they need to file for bankruptcy, if any of those things happen, the people are going to say, wait, there's an account with your name on it that has X amount of dollars in there. And they're going to assume that some of that money, at least some of that money, belongs to your child that you've put on there. And so oftentimes putting other people on your account puts your account at risk to whatever that person has going on in their life. And so you want to be very careful when you do that. Same thing with the deed to the family home. People have called and they had their children on the deed, and then they decide, it was their house, they paid the mortgage, it may be paid off, or they're paying the mortgage, and they just decided to add their kid to their deed. Okay, well, a few years down the line, they want to sell their home, but they can't sell their home without their children's approval, or whoever the person they've put on there, they have to get their approval because they are a co-owner. And there have been cases where there's a dispute there and they're just like, well, I just put them on there, but then they became a co-owner. And so you have to get their approval to do anything with the property after you add them to the deed. So these are things that I want to make sure that you are considering before you take these actions. If you die without a will, the state of Georgia determines who gets your things. And your assets may be distributed equally between your spouse and children. And so, a lot of people are like, I want everything to go to my spouse and then to my children. Well, Georgia doesn't think of it that way. And so if you don't say what you want, Georgia has already determined what they feel like is in your best interest. And that is for it to be split between your children and your spouse. your children may be given equal amounts, but their needs may be different. And this really speaks to, you may have a child that's a brain surgeon and a child that has special needs. Well, they don't need equal amounts. The brain surgeon probably doesn't need anything. He's probably good, but your child with special needs may need a little more, you may need more money to sustain him. You may need to have done some planning to make sure that he's going to be okay. But Georgia doesn't take any of those things into consideration because it is a one size fits all kind of a template they have. And so they are not taking your particular set of circumstances into consideration. They have the same template for every family if you don't do your planning. And then probate court will decide who will be the guardian of your minor children or other dependents. And so those are all things that can happen. Another thing that I see that happens in our community is there may be someone that you raised like a child, or there may be someone, that was a stepchild that you were really close to. Well, those aren't legal relationships in Georgia. And so a stepchild does not stand to inherit. Someone that you took in as your child but didn't do the paperwork, never formally adopted them, they won't get anything. And so oftentimes when we have blended families, or we have people that we've cared for that aren't legally our children, we have to plan in order for those people to be able to inherit or get anything, because otherwise they just won't. The other option is a trust. A trust is a legal entity set up to hold ownership of your assets. There's a grantor, which is the owner of the trust. There's a trustee, which is the person that is following the directions in the trust. And there are the beneficiaries. And those are the people who stand to benefit from the trust. A trust can be revocable, which means you can put things in and take things out. Or it can be irrevocable, which means you put things in and it locks and you can't take it back out once it's put in. The benefits of a trust is it avoids probate. It can prevent the court from controlling the assets if you have some incapacity that happens. And it really brings all of your assets under the same roof. It brings it together in one plan, because part of the trust means it retitles things into the name of the trust. And so everything is kind of brought together. And it's private. So when you have a trust, you don't need to go to probate court. No one knows what is in your trust except you, the people you've listed as the trustees after you pass, and the beneficiaries that stand to inherit. Probate and probating a will is a public process. And so people have access to the will, have access to the filings, and a trust is private. And then an irrevocable trust we often use when we do elder care work with this which is long-term care planning. And it allows you to qualify for assistance and to pay for long-term care while also protecting your assets. And I think I've gone through this. A will doesn't avoid probate. Probate is a court-appointed process of reviewing your will, making sure it's valid. And so the court really oversees the probating of your estate. A trust doesn't have that. So then the question becomes, because people who don't decide to move forward with planning, the number one objection, besides, not wanting to deal with like death, not wanting to think about that, or not having time, is the cost. And so the question is, can you afford to be cheap with your legacy, with the things that you have built and accumulated over your life? Which brings me to another client. who called my office and said, Ms. Smith, I need your help. My grandma died and she wanted me and my aunt to split her assets. Also, an older Black lady, this is in Clayton County, who had accumulated property and had accumulated some large pieces of property. She wanted me and my aunt to split her assets 50-50. I'm her favorite grandchild and I've taken care of her when she was sick. That my aunt is the last living child and she wanted us to split it 50-50. And I said, okay, great. Well, is there a will? And he said, yes. I said, okay, send the will over. You know, we will get started on getting this will probated. And he sends the will over and I read the will. Then I read it again and I call him and I said, the will doesn't say what you said your grandma wanted. And he was like, what do you mean? And I said, the will says everything to your aunt. And if your aunt predeceases your grandma, then it goes to you. It doesn't say everything is to be split between your aunt and your grandma. And I asked him, I say, well, I said, did an attorney draft this will? And he says, no. I said, well, who drafted the will? And he said, I drafted the will. And I said, are you an attorney? And he said, no. And I said, well, you have drafted yourself out of the will. You have drafted yourself out of inheriting 50% of what your grandma had. You drafted yourself out of being able to have what the 50% your grandma wanted you to have. And he was like, well, can we contest it? And I was like, a will that you drafted? No, like, no, we can't. And he was sick. He was sick. And he said, well, my aunt was there. Like, she knows what my grandma said. And I was like, okay, well, if your aunt is willing to give up half to you because she knows that's what your grandma wanted, even though that's not what the will says, then we can do that. And I'm just going to let you guess what his aunt said when he went to her. She wasn't having it. She was like, it is all mine. Like, if that's what the will says, it is all mine. And there was nothing we could do simply because he was like, I didn't really want to pay somebody to draft the will. I felt like I could do it myself. And he did himself. He did do it himself, but he had no idea what he was doing. And he wound up paying me double, at least double what he would have paid just to get the will drafted by a professional, by an attorney. So now we're going to talk about the life documents. The power of attorney, the will and the trust we really think about as death documents. Those are documents that really dictate what happens after I pass away. There are other documents that dictate what happens if I become incapacitated. What happens if I can't make decisions for myself? And those, but I'm still here. I'm still here, but I may be incapacitated. Those documents we refer to as life documents. The first one is the power of attorney. So this says that the will structures how you want your financial handle upon death. The power of attorney decides that if you become disabled or otherwise incapacitated. It allows you to designate another person to speak and act on your behalf in financial and medical situations. So there's a healthcare power of attorney, and there's an advance directive for healthcare, and then there's a financial power of attorney. You do not lose decision-making rights when you appoint this person. You only allow them to act on your behalf if they are needed. And the extent of your power of attorney granted to your agent depends on what you are willing to give. It really depends on you. You can give them all the powers, or you can limit the amount of powers that you give them. In most situations with my more seasoned clients, my advice is to find someone you really trust and give them as much power as you can. That's really my advice. So powers of agent, your agent may be authorized for financial agent to pay bills, access bank accounts, sell property, handle tax situation, and other financial affairs in your name. Your medical agent may be authorized to make medical decisions in case of mental or physical incapacity. And so I want to just note here that I often get parents who feel like they have to give it to the oldest child. Their agent has to be the oldest child because they're the oldest. And what I want, as you think about doing your estate planning or your elder law planning, and you're thinking about the different people that are going to fit in these different roles, what I want you to think about is who is going to be the best person for this role? Who's going to be the best steward of what I'm giving them? Who's going to be able to make these decisions? If your oldest child has had 5 bankruptcies and they're always asking you for money because they never have any of their own, they may not be the right person for your power of attorney agent. And it doesn't even have to be someone you're related to. It doesn't have to be a child or a spouse or a sibling. It can be somebody at church that you really trust. It can be a neighbor. It can be a friend. There are no requirements on who it has to be. You just need to make sure it is somebody that you feel would make good decisions on your behalf, that someone that you really trust. For healthcare power of attorney, you want to make sure it's someone that thinks well under pressure, that doesn't get really emotional, that would be able to stay calm and collected and consider all of the options and make the option they think you would want, not that they would want, but the option that they think you would want. And so these are important things to consider when we're picking who is going to be that person that will be our agent. And so what happens when we leave our legacy to chance? That's my last question to you. And I will tell you, at the beginning of December, I had a trial. It was a guardianship trial. One of the most contested, contentious hearings I've had in a long time. And it was siblings fighting each other on who was going to take care of dad. And of course, dad had some money, but you have to consider dad did really well in his life, had accumulated assets, had obviously treated, because all of these were stepchildren, had treated them really well. They all really loved him, but dad hadn't really done all of his planning in the way that he needed to. And so now he has dementia. He's he didn't have capacity, but he has to sit in a courtroom and watch all the people that he loved the most beat each other up and say the most horrible things about each other. And then, by the way, say not really kind things about him either, because they have to prove that he does not have capacity. And in some ways, I was just like, this is worse than like a probate case where there is litigation and people are fighting about who was supposed to get what, because at least that person is dead. They're not going to be there to witness that. But dad was right there. Dad had to testify. It was heartbreaking. And besides that, the amount of money that these siblings paid out to fight each other about who was going to take care of dad. People think when we talk about not planning and leaving things to chance, they think about, okay, after I pass. It doesn't have to be after you pass. You can still be here and these things come into play. And so I tried with my clients several times to say, can we just come together and come to an agreement? Because in these situations, it's so emotional. Nobody's thinking clearly. And the only people that are winning is the court, because they're getting their fees, and the attorneys, because they're billing for all of this. And my clients would not have it. And so we wind up a full day of court with dad having to sit there and listen to all of his kids say really unkind things about each other. That is what can happen when we leave things to chance. So, when is the best time to do your estate planning and plan for your now? Now, I think one of the things that COVID in 2020 and 2021 taught us was we have no idea what tomorrow brings. We have no idea what the future brings. And I think estate planning is one of those things where we always feel like, okay, we have some more time. Okay, I'm gonna put that on my list, and it just keeps working its way further and further down the list. And we never get to it. And so now is the time. It's a new year. We're still in January, barely. Now is the new time to commit to getting this done. And we love stay in touch. These are all the different ways that you can contact us. Phone number, our website, we are on social media, and we have a podcast that has a new season coming out February 15-ish, around the middle of February. It's called Black Parents Aging. You can access that on anywhere you listen to podcasts, Apple, Spotify, however you listen to podcasts, you should be able to get our podcast there. If you've never heard it, we already have 30, 40 episodes that have been so enlightening and helpful to me. And so I think, they would be the same for you. And then the offer is a free consultation if you schedule by this Friday. The consultation doesn't have to happen by this Friday, but it needs to be scheduled by this Friday. And with that, I am happy to unshare, stop sharing, and take if there are any questions that anyone have, I would be happy to answer those.
Okay. There is a question in the chat.
Okay.
What do you recommend for long-term care? Should we get a long-term care policy, or are there other instruments that can help for this?
So yes, long-term care insurance is great. Oftentimes, by the time clients come to see me, it's almost cost prohibitive. Because as you get older, it's a better risk that you're going to actually need the insurance, and so the price goes up. And so oftentimes by the time you're in your 60s or 70s or even late 50s, sometimes the price is just so expensive that when clients come to us, they're like, okay, we can't afford long-term care insurance. Like, what's the next option? The next option would be elder planning. Elder planning works in the following way. The only program that I am aware of that pays fully for long-term care, nursing home care is Medicaid. Medicaid is means tested, which means they are looking at both your assets and your income to see if you qualify. What other folks have been doing for years and years and decades that a lot of us don't know about is, if you are able to put some of your assets, as much of your assets as you can, in an irrevocable trust, there's a 5-year look back with Medicaid. After that 5-year look back, it's like they don't exist anymore. Because since it is an irrevocable trust, you don't have access to it. It doesn't count as an asset to you. Now, if you're over the income level, that's pretty easy for us to fix. but it's usually the assets that get people. And so if you're able to plan ahead of time around the 60, 65, when you are still healthy, and say, okay, I want to put this away because I want to make sure this goes to the grandkids. I know that, you know, it's locked to me, but I know that it's going to go to those grandkids. And so that's where I want it to go. You're able to protect whatever that is, and still be able to qualify. And even on the irrevocable, you can't be the trustee, you can't be the lifetime beneficiary, but oftentimes your kid is named the trustee or the lifetime beneficiary. Now, what they do with that is their business. If they give it to you, you know, it just can't go to you on paper. And so a lot of times that is how people get around being able to qualify and pay for long-term care.
The next question. The man who used the template for the will, did he write himself out, or was the will because of he didn't have two witnesses, or because he wrote it incorrectly?
He wrote himself out because he wrote it incorrectly. So he thought he was writing one thing, but what he wrote was another. He thought he was writing, it goes to me and my aunt equal shares. What he actually wrote was it all goes to my aunt. And if my aunt predeceases, then it goes to me. So he thought he was saying 50-50, and what he was saying was 100, and then he was the backup. Any other questions? Okay, no other questions. I will just say thank you so much for having me. Please take advantage of the free consultation. It's usually $250. So please take advantage of that. Call the office, schedule before the end of the week. And I'm happy if there are some questions that come up after that you guys want to email, I'm happy to answer those. And I'll give you my direct email. It's Olivia, OLIVIA at srlawgrp.com.
You want to add it to the chat?
I will.
That'd be great. Okay, and while you're doing that, I will share my screen and just share with the group that we have continued an initiative while we have a captive audience to share some information. And I think there may be a member of the committee that will share some information around chronic kidney disease and some of the work that the Lynx is doing with that.
Good evening, everyone. I'm Constance Hendricks, chair of the LaGrange Black Care Initiative, and Jackie Jones is also on, and many of our ad hoc committee members are here supporting our collaborative initiative tonight. We want to share with you that we have conducted 2 great webinars. And so after this session, you will receive an email from us with links for both of those sessions. The first one was entitled, I Never Knew I Had Kidneys. And the second one was one we just had last week. And Jackie, help me, I just had a senior moment. A Walk in My Shoes, with a panelist of persons who are living with chronic kidney disease from stage 1 all the way through stage 5 and successful on the other end. And so we believe that those 2 sessions will provide you meaningful information. We will also send you the electronic flyer and a few other tidbits. And stay tuned. We'll have at least one session in the month of February and one in March. Stay tuned.
Thank you so much. We have a great deal of information. It's exciting to be able to share some information that helps our community. So thank you very much, Dr. Hendricks. And I will turn it over to our chairperson, Emma Huff, the chair of National Trends and Services Facet.
Thank you so much. This has been wonderful. To Attorney Olivia, you've done it again. This was part 2, and look out, there may be a part 3 coming, because you're very good. You explain it so well, and I think it's on a level in which all of us can understand it. And the information given is something that all of us need to know. And this in addition to other things. And I know a lot of you have questions and want to know more information about this or that or whatever. But if you just jot those down, and as she said, you can email her and get some information that you need, that's burning on your heart. So I know for me, some of the little things that she said, it sparked something within me. So I need to get more information about it. So if you feel that same way, jot it down so you won't have a senior moment like me and forget what it is. So just write it down and keep up with it, because as I said, this information that was given to you tonight is something that all of us must be proactive with. We need to start now, as she said. We can't wait until tomorrow, because you know how it is. We're here today, and sometimes we're gone today. So you have to really start doing it while you can. And thanks so much, Attorney Olivia. You did an awesome job, as you did before. And as I said, I think we may want to look at a part 3. So there are so many things that we need to know that we don't know. And as a Black race, we kind of shun about doing things that will help and protect us. And also to link Constance, they're working on this Black Cares Act initiative. And it is we just don't take care of our bodies like we should. As she said, the question was, I didn't know I had a kidney. What is a kidney or whatever? But we have so many people that are getting on dialysis and this kind of thing. And so please stay tuned to some of the webinars that they are presenting to help you with your health. And all of it ties in together, because your kidneys can lead to dementia or other things that what the estate planning all will come into play, because we don't ever know what's going to happen to us. So both of these things are something that we need to know more about. And with that being said, on behalf of the National Trends and Services Facet and the Intergenerational Committee and the Black Cares Committee, we thank all of you for being a part of this and supporting. And just let us know, give us some feedback on whether you liked it, whether you want to do it again, or what can we do to help you. So just give us some feedback and let us know what we can do. And thanks to the Links Incorporated, our chapter in Atlanta, in LaGrange. And at this point, I would like to ask if our president would have some closing remarks.
Just want to thank Attorney Smith for all of that very valuable information. Thank you for coming to us again and working with us. Very helpful information. And as Link Emma said, sometimes we're reluctant to act on this kind of information, but it's what we do need to do. So including me, we all need to not put off until tomorrow what we need to do today. Thank you all for joining us. Enjoy your evening. And with that, we are adjourned.
Thank you.
Pressure by the D tackles right in the face, and that is why you have to stay.
We'd just like to thank all of our guests. We have 2 Alabama judges, I understand Judge Pettaway and Judge Cooper. I'd like to thank them for joining us this evening.
Thank you.
That ends our session.
Thank you, Carol.
You're very welcome.